Welcome back to Mastering Contracts. I'm your host, Professor Seth C. Oranburg, and today we're diving into a doctrine that provides a way out when performance under a contract becomes impossible, impracticable, or no longer serves its intended purpose. This is the doctrine of excuse. When something unexpected happens that makes fulfilling a contract untenable, the law can step in to offer relief. Imagine agreeing to deliver goods only to find out the day before that a government embargo made your shipment illegal. Are you still obligated to perform? Are you liable for breach if you don't? Today, we're exploring when the law says, "Excuse me," to non-performance and lets you walk away without penalty. In our last episode, we discussed anticipatory repudiation and how parties deal with breaches before performance is due. Today, we shift gears to focus on the doctrine of excuse, where the obligation to perform can be legally wiped away due to unexpected events. By the end of this episode, you'll understand the key elements of the excuse doctrine, the types of situations where courts relieve a party of duty to perform, and how doctrines like impossibility, impracticability, and frustration of purpose play out in real-world cases. If you've ever wondered what happens when performance becomes impossible, impractical, or when a contract is rendered meaningless, stay tuned. We'll break down these concepts and show you how courts excuse parties when circumstances change. Now that we've set the stage, let's dive into the doctrine of excuse. This doctrine provides a way for parties to be excused from their contractual obligations when unforeseen events make performance impossible, impracticable, or when the purpose of the contract is frustrated. The first key concept is impossibility. This occurs when performance becomes objectively impossible, something that simply cannot be done anymore in physical reality. A classic example is the destruction of a specific good that was essential to the contract, or the death of a person who is central to performance. If you agree to sell a unique piece of art and it's destroyed before delivery, or if someone agrees to perform at a concert and they pass away before the event, performance is literally impossible. The law will generally excuse that contract performance. Next, we have impracticability, a less stringent standard. Even though performance might still be technically possible, it may become so difficult or so expensive that it no longer makes sense for the law to require the promisor to follow through. Courts will look at the degree of hardship or expense, and if performance has become unreasonably burdensome, the contract may be excused. It's important to note mere inconvenience or a bad deal in hindsight isn't enough. Parties seeking the impracticability defense needs to show a significant and unforeseen change in circumstances. Finally, we have frustration of purpose. The frustration doctrine applies when the underlying reason for the contract is destroyed, although performance is still technically possible. For example, if you rent space to a host for an event and the event is canceled due to a change in law, or perhaps if you rent space for a yoga studio and you can't operate that business because COVID-19 lockdowns prohibit that activity, you might be excused from paying for the space, or you might not. Courts look at whether the event or purpose was a principal reason for the contract, and if so, the contract may be voided. But contracts may also have clauses, such as force majeure clauses, that talk about what happens in these situations. When the parties have agreed in advance, in writing in their contracts, to what happens in these situations, those force majeure clauses generally prevail over the excuse doctrines of common law. Let's break down the doctrine of impossibility with the classic case, Taylor versus Caldwell. This 1863 decision laid the groundwork for how courts excuse contractual performance when it becomes truly impossible. So here's the situation. The defendants leased a music hall to the plaintiffs for a series of concerts. Everything was set. The dates were agreed. The plaintiffs were gearing up for the events. Brochures, flyers were sent out advertising it. But before the first concert took place, disaster struck. The music hall burned down in an accidental fire, leaving nothing but ash. With no hall, the defendants couldn't fulfill their end of the bargain, and the plaintiffs sued for breach of contract, seeking damages for their lost profits and for their expenses. The court, however, ruled in favor of the defendants. Why? The judges recognized that the contract was fundamentally premised on the existence of the music hall. Without the music hall, performance wasn't just inconvenient or expensive, it was physically impossible. The fire destroyed the very thing on which the contract was formed. This ruling gave rise to the doctrine of impossibility, which allows courts to excuse performance when an unforeseen event destroys the basis of a contract, rendering performance impossible. In this case, neither party caused the fire, at least according to the facts that we have, and neither party could have reasonably foreseen it, according to the facts that we have. So taking the facts as given, the destruction of the hall wasn't something anyone planned for. And the contract didn't have a force majeure clause that dealt with the situation. The contract didn't address what should happen if the concert hall was destroyed, since the risk of loss wasn't allocated in contract, and since according to the facts were given, neither party was at fault or bore this risk, the court stepped in to find a fair resolution. Holding the defendants liable for something perceptibly beyond their control would have been unjust. It's important to note that the impossibility applies only when performance is truly, completely, objectively impossible. This is not about a task being harder or profits going down. It's about situations where the agreed performance simply can't happen. Imagine a venue you've rented for a trade show gets flattened by a hurricane. In that case, you could argue the contract is excused because the venue, the core of the deal, no longer exists. But impossibility has its limits. Courts apply the doctrine narrowly to ensure it's not overused. If the event could have been anticipated, like if you had an outdoor event in Florida in October, there is a risk of hurricane that we know about. Or if the parties had already allocated the risk in the contract through a force majeure clause, which might say something like, if there is an act of God, then the vendor does not have to perform. Well, then the doctrine doesn't apply because the parties have accounted for the situation, and it only applies when the situation is unforeseeable. If performance is still physically possible, even if it's difficult or expensive, impossibility doesn't excuse it. There is a related doctrine called impracticability that will come in. But for now, note that the case of Taylor v. Caldwell is foundational because it sets a precedent for fairness in contracts when the unexpected occurs. It underscores a key principle of contract law. Parties shouldn't be held to promises they can no longer keep due to events beyond their control. The case gives us a framework for handling impossibility, and it's still highly relevant today. There are things that cause impossibility to occur, including government regulation. I've already referenced COVID, and we'll talk about it again. And I know it's something we'd all like to forget, but it was a time that really brought this doctrine to the forefront, especially regarding sporting events. So from burned down music halls in 1863 to hurricane-damaged venues in modern times to COVID lockdowns that happened just a few years ago, the lesson is clear. Impossibility isn't just about what's fair, it's about acknowledging the limits of what's feasible when contracts take an unfortunate turn. Let's explore some what-if scenarios to see how well you understand the doctrine of excuse so far. Here's the first one. What if you're contracted to provide catering services for a large corporate training event, but 2 days before the event, a severe flood damages the venue and makes it uninhabitable? The corporation doesn't want to pay you for the catering. Does the corporation have a legal excuse for non-performance, or do they have to pay you for the food you've prepared? Well, in this scenario, the corporation is likely excused from performing due to frustration of purpose. Without the venue in which to hold the event, the corporation likely has no need of the food you'd supply to the event. It's also unlikely that the corporation is somehow responsible for this third-party venue. And so the corporation would likely be excused from the contract, and you'd likely be excused from supplying the food. Let's try another one. What if you've contracted to ship flavored vaping products, the tobacco stuff, to California? But halfway through, new state regulations ban the shipment of flavored e-cigarettes because e-cigarettes with flavors have been made illegal in California. Are you excused from fulfilling this contract? Yes, the situation falls under the doctrine of impossibility. The unforeseen regulatory change has made it illegal to ship the vaping products into California, meaning performance is impossible without violating the law. Courts are not going to require you to violate the law, and so they will excuse your non-performance due to a new legal barrier. Finally, what if you rent out an auditorium to host a concert, but the lead performer cancels the tour due to unforeseen health issues? Now, are you able to cancel the contract because you're not going to make money because you don't have your lead performer? This is a much harder question. Perhaps you should have an understudy available, and perhaps you have the risk of loss and should have something in the contract with your performer to deal with being compensated in the case of cancellation. This one, it's not so clear whether you're going to get away with not paying for the auditorium where your lead performer canceled the tour. Now, remember that the doctrine of impossibility is objective and complete, but the modern doctrine has been broadened to impracticability. Let's break it down with another case, Transatlantic Financing Corporation versus United States, which explores how the impossibility doctrine broadened into impracticability. In this case, transatlantic financing was contracted to ship goods from the United States to Iran. However, the Suez Canal, a critical shipping route, was unexpectedly, at least according to these facts, closed due to a geopolitical conflict in the region. Egypt, who controlled the canal, decided to nationalize it and effectively blockaded it. Instead of canceling the shipment, Transatlantic rerouted the goods through the much longer and more expensive route around the Cape of Good Hope, a much longer delivery. But the delivery was made. Transatlantic sought additional compensation from the U.S. government for the increased costs due to the closure of the Suez Canal. The court rejected Transatlantic's claim for more additional compensation. It noted that this wasn't impracticability. While the route became more expensive, it did not render performance impracticable under the legal standard. It was somewhat more expensive, but not more expensive enough. How much is enough? Well, the court doesn't say because they didn't actually find impracticability occurred here, but they suggest that something like a 10 times increase in cost might be enough. It certainly depends on the facts and circumstances. The court also emphasizes that this closure wasn't totally unforeseeable and that the shipping lanes are within the control of the shipper. It's not the United States, but rather Transatlantic that decides what routes to take and when to take them and how much to charge based on their probability of being opened or closed. So for all those reasons, impracticability just didn't apply here. And it reminds us that impracticability requires more than just financial difficulty or inconvenience. The performance must be virtually impossible, not totally impossible, or so excessively burdensome that it fundamentally alters the nature of the contract. Look, the goods were delivered. It was a higher cost, but the fact that they actually got to port suggests that this was not an impossible and even impracticable contract. Let's fast forward to a modern example with similar circumstances, because in 2024, a series of attacks on ships near the Red Sea led to a significant reduction in shipping traffic. As a result, many shipping containers also had to divert their vessels around the Cape of Good Hope. It was just as in the transatlantic case. This detour added significant time and cost to deliveries, especially regarding oil. And around the world, prices of oil and oil-derived products increased because of this piracy and attacks in the Red Sea. So is this basis for a impracticability defense? Well, probably even less so than in transatlantic, especially if you're downstream from all these effects and you are simply paying more for oil. Remember that the gas and oil is still coming through. It's coming through over different routes, and it is simply somewhat more expensive. So claims for additional compensation would likely be rejected here as well. Global events such as geopolitical conflicts or security threats may or may not be unforeseen or unforeseeable as well. It's certainly unfortunate that these type of conflicts happen, but they don't automatically excuse performance. We do know that geopolitical conflict happens, especially in particular regions of the world that are prone to piracy, we might have disruptions in shipping. For a party to claim impracticability, they must show performance is practically impossible, not just expensive or delayed. And so the standard is consistent from the historical case of transatlantic to the modern shipping disruptions in critical trade routes. Today, we're going to break it down a third time because we have a third concept for this episode, the concept of frustration of purpose. And Krell v. Henry is one of the most famous cases illustrating the doctrine of frustration. The frustration doctrine is different from impossibility and impracticability because those doctrines are about whether performance can happen. They're about whether or not it's possible or impracticable to actually conduct the behavior considered by the contract. Whereas the frustration defenses are about whether the purpose of the contract, as opposed to its ability to be performed, whether the purpose of the contract has been destroyed by unforeseen circumstances. As a result, frustration of purpose is typically a buyer's remedy because they don't want the performance anymore, whereas impossibility and impracticability are typically seller's remedies because they can't perform anymore. So here's a frustrating story. Mr. Henry agreed to rent an apartment, a flat, from Mr. Krell for 2 days. He paid a lot of money for this particular flat at this particular time. Why did he pay so much for this apartment? Well, this flat overlooked the route of King Edward VII's coronation procession. Henry's sole reason for renting the flat was to watch the procession, and both parties knew this. That's why it had such a high value, had windows overlooking Pall Mall. But as luck or misfortune would have it, the king fell ill with appendicitis. The coronation was postponed, the procession didn't happen, and Henry refused to pay the rent. Krell sued for breach of contract, and the court sided with Henry. They reasoned that the flat's value was tied to its location and its view of the coronation procession. The purpose of watching this was so central to the contract that when the procession was canceled, the agreement lost its fundamental purpose. The court excused Henry's obligation to pay, stating that the purpose of the contract had been frustrated in a way neither party could have foreseen. This is a classic example of frustration of purpose. Performance wasn't impossible. The flat was still available. It certainly hadn't burned down. Henry could still use it. But it didn't serve the purpose for which the contract was made. The purpose of the contract was frustrated. The court recognized that enforcing the agreement under those circumstances would have been unfair, as the parties never intended for the contract to apply in a situation like this. So, how does the frustration doctrine work? For a frustration of purpose to apply, 3 legal elements must be present. First, the purpose of the contract must be shared by both parties. Second, that purpose must be completely destroyed by an unforeseen event, kind of like impossibility. And third, the event must not be the fault of either party. If a party's at fault, they can't use the defense or excuse. And by the way, modern courts have broadened this as well, such that the purpose does not have to be completely and utterly destroyed, but it's a sort of flip of the impracticality doctrine, where it is destroyed to such an extent that the meaning of the contract has been substantially frustrated. But in this historic case, Krell v. Henry is a powerful example of how courts consider the context and purpose behind a contract when deciding whether it should be excused. It's also a reminder that frustration of purpose is a narrow doctrine. Courts apply these excuses sparingly, often requiring that the frustrated purpose be at the very foundation of the agreement. In modern times, we've seen frustration of purpose during COVID-19 too. Imagine a contract for a wedding venue that became virtually useless when gatherings of more than 10 people were prohibited. The venue, which was designed to house 300 guests, is still existing, and the wedding theoretically could still happen with 10 people present and social distancing, but not in the way that the couple intended. In cases like these, frustration of purpose may provide relief, depending on the specifics of the agreement and local law. Krell v. Henry shows that contract law isn't just about rules. It's about fairness, context, and understanding the true intent behind an agreement. When unforeseen events render that intent meaningless, courts step in to ensure justice is done. Now let's turn to a real-world example of contract excuse that impacted almost every sector: The COVID-19 pandemic, the sudden lockdowns, government regulations, and public health orders made it impossible for many businesses to fulfill their contractual obligations without violating the law. How did courts handle these disruptions under the doctrines of impracticability and frustration of purpose? Well, when the pandemic hit, businesses that relied on events, travel, and in-person services were suddenly faced with government-mandated shutdowns. Contracts to rent venues, provide catering, or supply goods were all thrown into turmoil. Entire supply chains shut down. Many businesses turned to the courts, seeking to be excused from their obligations. Of course, the courts were only taking these claims virtually as well. The parties claimed impracticability, arguing that it became impossible to perform their contracts safely or legally, or virtually impossible. And others invoked frustration of purpose, claiming that the entire purpose of the contract was destroyed by the pandemic. Courts handled this in various ways, but for the most part, contracts were excused. And we have huge repercussions from this because entire industries and supply chains shut down in the process. One major example involved event venues. Imagine you had a contract again to have a wedding in 2020 or a Super Bowl, but suddenly due to health regulations, gatherings of more than 10 people are banned. This is a pretty clear case where performance is probably frustrated. You can't hold the wedding because you can't gather your crowd. On the other hand, it's probably impracticable. You may not even be able to use the facility. These are very good cases where excuse is going to be granted, and they generally were. Courts granted excused performance in such cases because government regulations make it impossible or purposeless to fulfill a contract. The COVID-19 pandemic was an unfortunate time that tested the limits of the excuse doctrines in contract law. In cases where performance became impossible, impracticability was often invoked. Courts would excuse a party when performance was rendered impossible due to government regulations, or potentially just from the health crisis. On the other hand, frustration of purpose was also applied when the underlying purpose of the contract could no longer be fulfilled. For example, venues still existed, but there wasn't a reason for renting them. Let's recap what we covered today. We started by exploring the doctrines of excuse in contract law, specifically impracticability and frustration of purpose. These doctrines come into play when unforeseen events make it impossible or meaningless to perform a contract. Impracticability, which is broadened from impossibility, excuses performance when unforeseen events make it physically or legally impossible or virtually impossible to fulfill a contract. Frustration of purpose applies where the contract can still be technically performed, but the underlying purpose or meaning of the contract is destroyed by an unforeseen and unforeseeable event. These doctrines are vital tools for courts to balance fairness in unexpected situations. If you enjoyed this episode or learned something new, please share it with your classmates or colleagues. Don't forget to subscribe so you don't miss the next episode. And if you have any questions or feedback, please feel free to reach out to me or leave a comment on the platform. Next time, we'll be shifting gears to talk about assent, how parties can agree to change their own agreements. Stay tuned. That's all for today's episode of Organized, the Business Law Breakdown. I'm Seth C. Oranburg, and I thank you for tuning in today and exploring the world of excuse. I hope you found it informative and helpful. And remember, until next time, keep your agreement strong and your argument stronger.